Very good evening, students. Very good evening, Sapna. Okay. I hope everyone is doing fine. So let's start this session. First of all, I welcome each one of you to my YouTube session on the Indian Evidence Act 1872. Okay. Thank you very much, Sapna, for clarifying that. So let's start with my brief introduction. First, my name is Sandeep Khatri. I have done my law from University of Mumbai and my LLM from Jindal Global Law School. By profession, I'm a teacher. My areas of specializations are the constitutional law, criminal law, commercial law, family law, and law of torts. Here you can see the link of my profile of Unacademy. Please do follow that to get all the updates about my special classes and plus courses. This is my Telegram channel where you can connect with me and ask questions related to judicial preparation. And this is my code KHATRILIVE. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive and interesting session. So today we are going to discuss some MCQs on the Indian Evidence Act, which will help you in your judiciary examinations. Like the upcoming one is the Rajasthan Judicial Services and in UK APO exam as well. So let's start this session with the first question. Before starting this, the questions, students, humble request, please first write down the question number. Like for example, question number 1, only numeric 1, and then whatever your answer is, like A, B, C, D, whatever you feel like. And here comes the first question. The Indian Evidence Act 1872 came into force on one of the important questions, students. First one to answer, a very good evening, Mosmi. First one to answer, Mosmi, followed by Sapna. One of the direct question, students. Shivani. Correct answer, students. 1st of September 1872. Nothing much to explain, but again, this is one important question. The law of evidence does not apply to which one? A. Affidavits. B. Arbitrator. C. Both A and B. D. None of the above. Okay. First one to answer, Mosmi, followed by Sapna and Shivani. And yes, students, this is the correct answer. Law of evidence does not apply to affidavits and arbitrator. A fact is said not to be proved when it is neither proved nor disproved. This statement is of the question is from section number 3. Make sure that you know the concepts of each and every term that has been mentioned in section number 3. First one to answer, Sapna, followed by Mosmi and Shivani. And answer is correct, students. This is the situation of not proved. Which of the following is a document? Very good evening, Amit. Welcome to the class. First one to answer correctly, Sapna, followed by Amit and Shivani. Student, the question is again from section number 3. One of the term that has been defined in section number 3 is document. So please go through with the definition of the document and the illustrations. Both are important. The answer is D. Which of the following is a fact? Choose the correct option. Again, the term fact has been defined in section number 3. First one to answer, Sapna, followed by Shivani and Mosmi. D is the correct answer, students. If a man heard something, if a man said something, if a man saw something, these all will be considered as a fact. So the answer is D. Which of the following is irrebuttable presumption? This question is from section number 4. First one to answer correctly is Mosmi, followed by Sapna and Shivani. A is the correct answer, students. The question was which one of the following is irrebuttable. Irrebuttable. Which irrebuttable here means which cannot be rebut. जिसको rebut नहीं किया जा सकता. ठीक है? So the answer is conclusive proof. Okay? The same question in a different sense. Which one of the following is rebuttable presumption? अब आपसे पूछ रहा है कौन सी presumption है as per to the section number 4 जिसको कि rebut किया जा सकता है. First one to answer correctly, Amit, followed by Sapna and Mosumi. Yes, students, D is the correct answer. May presume and shall presume. Both are rebuttable. Facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact, and if they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Under section first one to answer correctly, Amit, followed by Sapna and Mosmi. And yes, students, the answer is correct. This is section number 11. Section number 12 applies to civil, criminal, both, none of the above. First one to answer correctly, Sapna, followed by Mosmi and Shivani. A is the correct answer, students. That is civil case only. Civil case only. If you can recall, section number 12 talks about damages. And when it comes to the concept of damages, that applies to civil cases only. Facts which form part of same transactions are relevant under section. I think the moment the word same transaction has been used, that must be very easy for you to find it out. One of the most important question, one of the most repeated questions, students, in your exams. First one to answer, Amit, followed by Sapna and Shivani. B is the correct answer, students. Yes, the concept of res geste. Admissions are Conclusive proof, not conclusive proof. Not to operate as estoppel of no value. You need to choose the most appropriate answer, students. That's the hint for this question. And first one to answer is Mosmi. Is answering A. Okay. What about others? Amit also A and Sapna also A. A is the correct answer, students. Please refer section number 31 for this one. Okay. Admissions, the term admission has been defined in section number 17. And then from section number 17 till 23 and 31. This is all about your admissions. And here the answer is not conclusive proof. Which of the following is irrelevant? Yes, students. I hope you can read all the options easily. Okay. First one to answer correctly, Amit, followed by Sapna and Pratibha. D is the correct answer, students. Admission made by a party who has not been expressly referred by a party to the suit, that would be completely irrelevant. Okay. And the section number from which the question is section number 18. Okay. So if you want to read more about it, go through with section number 18. Confession made after inducement, threat, or promise has been fully removed. It is relevant under section . First one to answer correctly, Sapna, followed by Amit and Shivani. C is the correct answer, students. This is basically talking about section number 28. Under which section confession before magistrate is relevant? Under which section confession before magistrate is relevant? First one to answer correctly, Sapna, followed by Amit. And Pratibha. Yes, students, C is the correct answer, section number 26, which basically takes you to the section number 164 of CRPC. Okay. Section number 32 does not speak of which of the following kind of persons. Out of all these options, choose the most appropriate one. First one to answer correctly, Sapna, followed by Amit and Pratibha. Top three to answer. Yes, students, D is the correct answer. Opinion of expert under section 45. Yes, correct, Amit. There is no concept of unwilling. First one to answer, Sapna, then Amit and Shivani. B is the correct answer, students. Opinion by expert is basically a supportive and corroborative in nature. Which one of the following section makes relevant opinions as to the existence of custom? First one to answer, Sapna, followed by Amit, Shivani. Yes, students, B is the correct answer. That is section number 48. Facts judicially noticeable. Facts judicially noticeable. I think the easy one. Question number 18 is from section number 56, and the answer is, students, Sapna, first one to answer, A, followed by Amit and Pratibha. A is the correct answer, students. बहुत बढ़िया मौसमी. Yes, these all sections talk about the concept of customs. Section number 56, Amit. Section number 56. Now, next question. Court can take judicial notice out of all these facts, of which court can take judicial notice of? First one to answer, Sapna. Followed by Shivani and Mosmi. D is the correct answer, students. None of the above. The details of an incident printed in a newspaper are categorized as. First one to answer correctly, Sapna, followed by Mosmi and Shivani. Yes, that is an example of hearsay evidence. Section 62 deals with first one to answer correctly, Sapna, followed by Amit and Shivani. A is the correct answer, primary evidence. Which of the following is not a primary evidence? First one to answer correctly, Sapna, followed by Shivani and Pratibha. B is the correct answer, students. A copy made from or compared with original. This is not a primary evidence. Special provisions as to evidence relating to electronic record was added. And first one to answer correctly is Sapna, followed by Amit and Mosami. D is the correct answer. Section number 90 applies to what kind of documents? Testamentary documents, non-testamentary documents, both A and B, none of the above. First one to answer correctly, Sapna, followed by Amit and Pratibha. This section is also important for that 30 years time period, students. That has also been asked several times in your exams. Execution of document may be presumed if the document is to be. I just told you the answer in the explanation of question number 24. First one to answer, Sapna, followed by Vipul and Amit. C is the correct answer, students, 30 years. Tape recorded statements are. What kind of evidence is tape recorded? Yes, correct, Amit. Electronic record, 5 years. First one to answer correctly, Sapna, 26, A, then Mosmi and Amit. This is documentary evidence, students. Remember section number 3 where the term evidence has been defined, and when you will read, the documentary evidence includes electronic evidence, and tape recorded statements are basically electronic evidence. So this is part of documentary evidence and not of oral evidence. In which chapter burden of proof are codified? Sapna, Shivani, Mosmi. Top 3 to answer, that is chapter number 7. Presumption of death under section 108. The person is shown to be not heard for a period of. First one to answer correctly, Sapna, followed by Vipul and Shivani. B is the correct answer. Which section is related with this maxim res ipsa loquitur? And write down the meaning of this maxim, the famous maxim as well, in your comments. Yes. Write down the meaning as well and the answer as well. Sapna, first one to answer correctly, Amit and Mausami. C is the correct answer, students. Res ipsa loquitur, things speaks for itself. सपना प्लीज एक बार क्रॉस चेक कर लेना हिंदी में भी यही है या नहीं है. घटना स्वयं बोलते नहीं, घटना नहीं होगी ये तो थिंग्स हो गई ना, थिंग्स. घटना तो सर्कमस्टांसेस होंगे शायद. प्लीज एक बार क्रॉस चेक कर लीजिएगा, ठीक है. हिंदी में थिंग्स स्पीक्स फॉर इटसेल्फ, ठीक है. सेक्शन नंबर 112. हाँ ऑलमोस्ट सेम ही है, ठीक है. ओके सपना. Section 112 applies when there is dispute regarding what kind of dispute we are dealing with when it comes to section number 112. It is about maternity, paternity, or both, or either A or B. First one to answer, Pratibha, followed by Amit and Sapna. B is the correct answer, students. That is, it is about paternity. Section 105 will apply to criminal trial. ये ट्रायल की स्पेलिंग मुझे ठीक नहीं लग रही है, गलत है. So criminal trial, civil suit, both, none of the above. First one to answer, Sapna, followed by Shivani and Mausami. And yes, everyone's answer is correct, students. Yeah, section 105 is basically the chapter number 4 of the IPC, general exceptions. So that is something which will apply on only in criminal trial. So that's why the answer is A. Presumption of section 113A pertains to first one to answer correctly, Sapna, followed by Shivani and Amit. C is the correct answer, students. Abatement of suicide by a married woman. Section number 113B was added in which year? I think that must be an amendment. Yes, through which amendment? Let me cross check this one. Okay. The correct answer is students A. And Shivani has okay, Sapna and Shivani answer is correct. And Pratibha. A is the correct answer, students. 1986. The term estoppel has been defined under section. Which section number define the concept of estoppel? First one to answer, Sapna, followed by Amit and Vipul. B is the correct answer, students. Section number 115. Who is not a competent witness out of these? Who is not a competent witness? First one to answer correctly, Sapna, followed by Mosmi and Anil. D is the correct answer, students. The answer is idiot. Now, the reasoning of this question I'm giving you in advance. That is, if a person cannot understand the question properly, then obviously he cannot be a competent witness as per to section number 118, and this is what the idiot is. Professional communication between advocate and his client. Choose the most appropriate answer. Students, I'm repeating again, choose the most appropriate answer. And yes, I got the correct answer. First one to give the correct answer is Mosami, B, followed by Pratibha. Students, try to understand. They are asking professional communication between advocate and his client. Now, not admissible. This is correct. But admissible with the consent of client. This is the most appropriate one. Okay. So the answer is B. Who is accomplice? Out of these all the options, who is accomplice? Yes, Mosmi, that was one of the exceptions of section 126. First one to answer, Amit, followed by Lord Grace and Shivani Mishra. C is the correct answer. Accomplice is a competent witness under section. First one to answer, Sapna, followed by Lord Grace and Anil Dikshit. D is the correct answer, students. Section number 133. Which of the following is not privileged communication? Out of all these options, which one is not? First one to answer correctly, Sapna, followed by Lord Grace and Anil Dikshit. Top 3 students to answer correctly. That is paternal. Yes. When shall the witness witnesses be re-examined? First one to answer correctly, Sapna, followed by Whipple and Grace. C is the correct answer. What number of witnesses will be required for the proof of any fact? Sapna, Amit and Vipul, top 3 to answer correctly. A is the correct answer, students. There is no particular number that has been given as per to section number 134. What is the object of cross examination? Sapna, total 50 questions, which means 8 more to go. And the object of cross examination is, first one to answer correctly, Sapna, followed by Amit and Pratibha. Yes, students, D is the correct answer, to examine the credibility of witness. Hostile witness means. What is the meaning of hostile witness? First one to answer correctly, Sapna, followed by Amit and Vipul. That is A. Hostile witness means unfavorable witness. For example, if I am the prosecution, I'm the public prosecutor, I have called one witness so that he can give evidence to the court that this accused has committed this crime. But now, whatever statements, whatever evidence he is giving to the court, that is something which is favoring the defense, or vice versa. If suppose defense has calling a witness and he is giving evidence as per to the favorable to the prosecution. So those are your basically hostile witness. Section number 159 provides for Okay, Amit has given the Hindi word as well, पक्ष द्रोही. बहुत ही अच्छा वर्ड है, पक्ष द्रोही. Okay. Okay, first one to answer correctly here is Mosmi, followed by Amit and Sapna. C is the correct answer. Witness can refresh their memory as per to section number 159. Impeaching the credit of witness under section. First one to answer correctly, Pratibha, followed by Mosmi and Shivani. D is the correct answer, students. Section number 155. Which of the following statements is correct? First one to answer correctly, Sapna, followed by Pratibha and Anil. Yes, students, C is the correct answer. Section number 165 you can refer. Which one of the following is the correct order of examination? Yes. Question number 47. First one to answer correctly, Sapna, Shivani and Adarsh. D is the correct answer. First examination in chief, then cross examination, and after that re-examination. Husband and wife shall be competent witness under civil cases, criminal cases, both, none of the above. And the correct answer here is, first one to answer correctly, Sapna, followed by Amit and Adarsh. C is the correct answer, students. Clerk and servant of barrister is in privileged communications under section. क्या बैरिस्टर के क्लर्क और सर्वेंट भी प्रिविलेज कम्युनिकेशन में आते हैं? कौन से सेक्शन में आते हैं? बहुत बढ़िया. सपना, अमित एंड आदर्श, टॉप 3 टू आंसर. स्टूडेंट 126 में तो कौन आएगा? बैरिस्टर आएगा. और क्लर्क और सर्वेंट किस में आएंगे? 127. Power of jury or assessors to put questions. I know this is irrelevant, matlab the concept is irrelevant, but the question may still come in the examination as the section has not been repealed till now. And first one to answer correctly is Sapna, followed by Mosmi and Amit. B is the correct answer, students. When you will go through with section 166, that gives the power of jury or assessors to put questions. And section 165 gives that power to the judge. Okay, so these were the questions, students. Now, any question you are not clear with, this is your time to ask questions. Anything. On any question you want my explanation on, students, one more thing I want to ask to each one of you, that are we done with Indian Evidence Act, or you want 1 or 2 more tests on this one? I guess we are done at least 4 to 5 already MCQ test on the complete Indian Evidence Act. So if you want me to move to the other subject, I can move to. So what would you say? Yes, please. Amit, conceptual classes are not possible. Reason because uh, there are many concepts and we have very uh, less time left for your UK APU exam and the RJS exam. So I guess it would be better if we can do more and more MCQ practice only. Because if I will go into the concepts, that will not help you in your PT examination. To clear the PT, you have to do more and more MCQ practice. Okay. Okay, how many of you are ready for IPC? Similarly, like I have done with Indian Evidence Act, I will continue with IPC MCQ test. Are everyone up for IPC, the Indian Penal Code 1860? Sure, Amit. Sorry, Sapna, we cannot start the CPC right now. Okay, Anil, you are asking about, sir, मुझे always confusion होता है bailable, non-bailable. Confusion होना नहीं चाहिए वैसे अनिल. ये क्वेश्चन भी आपके CRPC का है by the way. तो what I will suggest you, देखो, let's make it easy for you. Please go through with section number 2A of CRPC first. Okay. Now 2A defines both the term. What is bailable, what is non-bailable. But after going through with section 2A, the concluding point is that it will take you to the schedule 1 of CRPC. And in schedule 1 of CRPC, when you will go, there you will find columns. And one of the columns is of bailable and non-bailable, which means in IPC, now suppose if you want to see that whether the theft is bailable or not bailable, whether the murder is bailable offense or non-bailable, you have to check from that chart. Now the second point, you don't need to remember this for each and every offense, but at least you should know about all the major offenses which we heard on a daily basis. Okay. Now the second point, when it comes to bailable offense, it is always the right of the accused to get the bail. But when it comes to non-bailable offense, it is always the discretion of the court. The court will decide whether the court will give the bail or not. Okay, so these are the basics of bailable and non-bailable. I hope this will help you. Okay, and these are very, very basics of CRPC as well. Okay, Mosmi, I will consider that as well in my mind. So as of now, what will I do? I will think on this, that what the other subject we will start. Maybe from tomorrow, or by maximum by day after tomorrow, we will start with a new subject, so that we can and most probably this is going to be IPC or CRPC, and whatever it will be, I will update this on my Telegram channel in advance so that you will know. Okay. And I'll choose that subject which will help you in your UK APU exam as well, and in your Rajasthan Judiciary as well. Okay. So that's it, students. Yes, Pratibha, we are going to cover minor laws as well, but not on YouTube. That I will take care of in my special classes on Unacademy. So there are 3 types of classes in Unacademy. First one is your YouTube class, as you can see. Second one is your special classes, which takes place on Unacademy app, and that is completely free of cost. You don't have to do anything. All you need to do is just log into Unacademy app and use this code KHATRILIVE, and you will get the access of the classes. So I will take that in my special classes, the minor laws. Okay. Okay, Pratibha. Sure. Yeah. So this is the schedule of my classes as of now. Now Monday 2 to 3 p.m. I will take in these classes. I'm going to take a lot of subjects. Okay, a quick revision of all the subjects, all the major subjects. So let's crack PCS J with Unacademy, compete with thousands of aspirants and stand out from the crowd. You will get all the subjects here, the major, minor, local laws, all the subjects are available for you. These are some special classes, features, interactive live classes, poll for learners. You can raise your hand and you can actually speak with the educator. You will get the notification, so you will not miss any of the classes. You will get the lecture notes and you can access it anytime, anywhere. These are some other features, like India's best educators are available for you. This is the free test series going on Unacademy platform. For example, these are the mock test going on, schedule of the mock test. These are the rapid revision series for RJS and HJS by Faizan Khan sir, Karan Sangwan sir, and Vishwani Bansal ma'am. This is the pricing plan and the plus subscription students. More the months, less the price. And you can always use the code KHATRILIVE for 10% off. And once you're a subscriber, you can attend all these classes. This is the YouTube and the Telegram channel of Unacademy. And on that note, students, that's it. Thank you very much. Like, share, and subscribe, because that really motivates us to come up with much better lecture series. Okay. Thank you, students. So now it's time to say peace.